Okay. So I'm Pam Metzger. I'm the director of the Deason Criminal Justice Reform Center. I want to thank you so much for joining us today for another in our CJR workshop series. This is an opportunity for folks thinking and writing in the area of criminal legal reform to continue to talk about ideas, and in particular to allow authors of works in progress to vet new ideas and share them with a community of people who are interested in engaging in scholarship and research on these topics. While people are coming in through the waiting room, let me just say a word about the Deason Center. We're a criminal justice reform center located at the SMU Dedman School in Dallas, Texas. Among our areas of expertise are the delivery of public defender services, the operation of small tribal and rural, or what we call STAR, criminal justice systems, and the operation of prosecutorial discretion at the screening and charging stages. So I'm thrilled to have with us today two of the three scholars who are working on this exciting project, Unwarranted Warrants. Miguel de Figueiredo, who is the professor of law and the Terry Titandro research scholar at the University of Connecticut, joins us with Dane Thorley, who is an associate professor of law at BYU. They are both JD PhDs. Brett Hashimoto, who is a third co-author, is an assistant professor of linguistics at Brigham and Young, and has also been a corpus linguistics research fellow at BYU Law School. He can't be with us today, but he is a co-author on this project. So the way we're going to organize things today, I'm going to hand things over to our presenters who have a short PowerPoint. They'll walk us through their PowerPoint. I may exercise the moderator's privilege at some point to ask a couple of questions before I hand it over to the crowd and open it up to our participants to share their ideas and thoughts. Once we do turn it over to the audience, I'd ask if it's at all possible, please do turn your cameras on. We all know what it's like being on the other end, speaking into a screen that's filled with little squares that just have a name and no faces. So once it is time for audience participation, we do hope you'll join us by sharing your face so we can listen to you. So with that, I'm going to hand this off to our presenters, and thank you again for joining us.
Well, thank you, Pam. I just want to say it's a real pleasure to be here. I was at a conference and on a panel with Andrew Davies, and Pam was supposed to be there, but it was right at the time when the Deason Center was being started. And it is just incredible to see all of the, how much it's grown and all of the incredible initiatives that are being done right now. So I just want to say it's a real pleasure to be here. I love the opportunity to get feedback both from academics and practitioners. And so I'm really looking forward to it. This project is titled Unwarranted Warrants, an empirical analysis of the search and seizure process. And as Pam said, my co-author, Dane Thorley from BYU Law School's here. Brett Hashimoto can't make it, unfortunately, but we are really just thrilled to be here. We are really taking this as a works in progress workshop. It's very, very early stage. So I'm going to show you kind of the questions that we're interested in answering, some basic, the data that we have, and some preliminary results. And I'll talk a little bit about where we're going with this. So with that, I'm going to sort of motivate this question by saying, you know, warrants have gotten a lot of attention in the media recently, right? We have the no-knock warrants that resulted in the deaths of Breonna Taylor and Amir Locke. And obviously with the recent search of Trump, right, warrants are taking on increasing importance and they're becoming increasingly salient. Not only is it sort of, you know, invasive raids and the like, but there's also a whole shadow set of warrants that take place in the background. Almost all of us, I assume, have a third-party email provider, a third-party cell phone provider. A lot of us have smartphones, which can hold a lot more paper, right, than probably what's in your house, right? And what's happening, right, is that the law enforcement are going to third-party providers with warrants, and then they can then do searches via the third-party provider. And so the privacy invasion is not just kind of battle random doors down, but it's also with IT kind of exploding and storage capacity exploding, also important to think about. And so it's hard because there's been so little empirical work in this area. It's hard to sort of really quantify the impact. I'll talk more about that in a minute. But here are some, kind of three things on the impact. First, from 2010 to 2016, there have been at least 81 civilians and 13 officers killed in no-knock raids. And I say at least because that's not an entirely systematic count, but that's sort of roughly what we're talking about in terms of deaths. But there's also billions of dollars in payouts that are being made for property damage, injuries, deaths, civil suits, and the like. And as I said earlier, on a more kind of visceral level, the privacy invasion is very high, right? Particularly in more marginalized communities. And so with that said, we don't, but with all of that said, we don't really know much about the empirics of the search process. And that's sort of a literature that we're trying to contribute to, a tiny literature. And I'll tell you more, there's only been 3 articles that I've been able to find with empirical work on warrants. And so, although they're very prominent, very important, we see that there's very little work done. I think there's a number of important implications. I've just teed up a few of them here. For any of you who are practitioners or scholars of criminal procedure, right? There's really important kind of trade-offs that we have to think about in terms of public safety and the state's ability to investigate crime on the one hand, but on the other hand, we need to think about the privacy interests of citizens. Secondly, judges are supposed to be a check on the process, like by design, and we need to think about whether that's actually happening or not, right? And so we have to empirically investigate whether it's happening or the conditions under which accountability is in place or not. Third, we want to explore the extent to which there are disparities in terms of who gets searched, right? And if there is discrimination, right, is it statistical discrimination, meaning it's like based on the likelihood of some group or individual to commit crime, or is it taste-based discrimination, right, where there are certain groups that are just by the way they look, or their income levels actually more likely to be searched. And then the impact, right? I think this is something that's not really talked about or has been studied enough, right? The impact of searches on communities and individuals. How does this having an effect on the legitimacy of the police and and the ability of individuals to report crime, the ability of individuals to work with the state. And finally, there's really basic questions about whether the law is being followed. And so one example is that no-knock warrants have a higher exigency threshold. Is that threshold being met, right? And so we have, this is just anecdotal, but we found examples where no-knock warrants aren't even being requested by the police and they're being granted. No-knock warrants, and then there's questions about the extent to which the thresholds are being met based on what's reported of exigency, right? Whether the facts, merit, evidence destruction or, officer safety or the safety of others. There's also Riley v. California, a Supreme Court case that, when there's a incident to a lawful arrest, so that, that you have to have a warrant for the search of a cell phone. Again, right? Our cell phones now carry tons of information, right? And so, and we can look at the extent to which there's compliance or not with court decisions. Something we haven't done yet, but that's just something we plan to do. possibly in the future. So to give you a quick overview of where we are, our overarching kind of research question is, to what extent is the warrant process a check on state power or not, right? And I'll talk more about what I mean by that in practice. And so to that end, we have 5 specific research questions, okay? The first question is, are judges or magistrates, are they actually reading the warrant applications, right? These are basically affidavits by the law enforcement officer. Second, is there variation in the approval rates across judges? And what are the determinants of approval, right? Now, I've said in the abstract that we're finding in a first submission, there's a 91% approval rate. And there is, a 97% approval rate after multiple submissions. And so one of the key questions is, well, is that high or not, right? And we could argue that maybe all of these meet probable cause, right? And there's sort of an equilibrium where the officers are learning early, and then they are, basically quickly able to sort of have probable cause, nailed down in a way that's credible. On the other hand, maybe not, right? Especially if the warrants aren't being read, and we're seeing that there are a lot of evidentiary challenges being made after. We can sort of test the extent to which the judges are an effective check or not on the state. Thirdly, to what extent are officers engaging in judge shopping? And we have some really cool, this is one of the few areas of the law where you can judge shop, right? And one of the really cool things we can do with our awesome, what I think is really neat micro level data, is we can look their judge shifts, right? And so an on-call judge will come off, let's say at 5 o'clock, and let's say Pam is the judge until 4:59, and I come on at 5. Well, is there a spike or a trough in the submissions that happen, right, before and after shift changes happen? Or what about how much repeat play is happening between officers and judges? And then that has an effect on the approval rate downstream. To what extent are there disparities in who's searched? And we haven't done any work yet in this area, but in a lot of cases we have the names, right? We can look at, let's say Latino names, African-American names, and then see if, what the hit rates are. We can also get administrative data to look at that as well. And then what are the downstream consequences of warrants being approved, right? Like, what are the effects, for instance, on how many warrants are being issued but not served? How many warrants that are approved are being, or what are the hit rates, excuse me? We have the returns on all these warrants. What are the hit rates, right? So, for instance, in the racial profiling literature, right, I think kind of one of the key findings is that, sort of blacks and whites, the hit rates are very similar, but yet blacks are searched at, 8 or 9 times the rate of whites. Well, what's going on about this in this area of the law? What are the hit rates, and to what extent is it actually mattering downstream in terms of things like indictments and convictions? Today, I am just going to focus on these first two questions, because again, we just took the shrink wrap off of this data, and so I'm sort of early. We're very early stage, and so just going to give you some preliminary results of these first few questions. Where are we doing this? We're doing this in Utah. I'll get into why we're doing it in Utah in a minute. And basically, the data that we have right now, we have really granular timestamp data at the second level that has the time at which a officer submits a warrant, a time at which the judge views the warrant, at which it's opened up on his screen, and then the time at which a decision is made, and we also have the time at which it's served. Okay, and so we have just under 4 years of data right now. It's being updated to almost the present, and then we have almost every approved search warrant. We have PDFs from December 2012 to January 2020, and that's soon going to be updated this is actually incorrect. It's through May of 2022 that we have the data. And then finally, we are in the process of requesting administrative data from the courts on probable cause challenges, indictments, and convictions, and other procedural variables that might be of interest. Okay, so just to quickly go through the literature, I've only been able to find really 2 papers, empirical papers on warrants. There's a really great paper done in 1986. Okay, so this is quite a while ago, by Van Deason, Sutton, and Carter, that they did a great study from the National Center for State Courts. Again, but they don't have a whole universe. They do 5 jurisdictions, and they do surveys to get at some of the data. But there's obviously some selection issues there. Benner and Marcos look at in San Diego at like federal warrants, and they have a very good study there with the prosecutor's office there. Tom Miles at the University of Chicago has a paper in the Journal of Legal Studies, and it is about wiretap warrants by the DOJ, but it's really not about warrants. It's really about what he finds basically is that almost 100% DOJ, if anything is even close to being rejected, doesn't submit. And what he finds is that so they almost have like 100% acceptance rate for their wiretap warrants. And what he finds, what he's actually looking at is the judge that's selected, right, is overwhelmingly white, right? So they find that there's basically discrimination in terms of who they go to, even though everybody has a virtual 100% probability of sort of getting the warrant approved. Research gaps sometimes exist as an opportunity, sometimes exist for reasons. And I'll say 2 key challenges is first that there's a dearth of data, right? So in a lot of jurisdictions, they're paper records, and so that's very labor intensive to process. And also the data, the metadata is not systematically collected. And so it's very difficult to study warrants. I tried looking at this in Connecticut, and oftentimes what you have is judges knocking on the doors of the judge's home even, and so you're not gonna see when warrants are rejected and things like that. And so when you only see approved warrants, right, there's a massive selection issue, and you're not seeing what the approval rates are, and that creates problems. And so what we've been able to overcome some of these issues with this data that we have. So we do this in Utah, the great state of Utah. So just to, and I'm going to get into the data on the next slide, but just to give you a sense of like the characteristics of Utah. Utah is about 3.3 million is the population, according to the census. It's about 1% of the US population. And it's a very white state, right? More than 3/4 of the state is white, but there is a pretty, significantly sized and growing Latino population there. And so we think we'll be able to do some work with Latino names and looking at the search probabilities there. And then you can see the Asian, Native American, and Black population, is in low single-digit percentages. Utah has 8 judicial districts and 29 counties. So districts are conglomerations of counties, and so you can see them here. Most of Utah's population, Dane knows Utah better than me, but correct me if I'm wrong, but is concentrated sort of in the Salt Lake and Provo area, which is sort of in this part of the state where I'm directing the mouse. And there's suburban areas around there. And basically, overwhelmingly, the warrants are approved by in our data, almost 100% by district court and justice court judges. Justice court judges are at the county level. And you basically have to have a JD and be a member of the Utah Bar if you're a district court judge. They changed the rules in 2016. You have to also be a judge and a member of the bar, before 2016, and after 2016, that's the case in large counties. But in medium and small counties, you just have to have a high school diploma or the equivalent. But in our data, there's only one judge without a JD. He has a bachelor's degree and an MA in accounting. There are interesting judges out there. There's a judge with only a high school diploma who was a trucker, actually, who owned a diner, but he, to our knowledge, has not approved any warrants. The appointments process, just so you know, basically they're appointed and then they have retention elections. So the governor appoints a commission in every district. They basically do the vetting, and then they have 5 nominees. The governor selects one that goes then for Senate confirmation. The initial appointment is for 3 years, and then they have a retention election after 3 years. A retention election, you run unopposed, and if 50% or more say no, then you can't. Then you're taken off the bench. It almost never happens in Utah, and those retention election appointments are for 6 years. So now I'm going to just tell you about the warrant process. This is a sort of, there's exceptions to this, but this is what by and large happens for most of them. So these are e-warrants, okay? There is a way, but we have talked to some DA offices, and there are very rare instances where they will just file a paper warrant. Those tend to be for very serious, high-profile cases. So we are missing some of those. We think it's less than 1% of the cases, but but there are those cases, that I just want to mention. But what happens is for the and again, these are search warrants, right? They're not bench warrants. It's not arrest warrants. These are just search warrants. And so what happens is the officer will log on to the system. He'll then submit the warrant, and there is sort of a template there that they have. It is to some extent boilerplate, but there are big windows where they put in the facts of the case and the experience and the charge and so forth. Then what happens is a prosecutor is going to be notified, and most of the warrants are actually, it varies by the jurisdiction, but most of the warrants are not reviewed by prosecutors. There's variation across districts. After review, then it's sent to an all-call judge, okay? And that's sent by email or text message. They can, if they want, specify a judge, particularly if it's a denial or a retraction. They can try to go back to the same judge if that's not the on-call judge. But overwhelmingly, we think that the on-call judge is handling most of the warrants, but not all of them. And then there's an on-call log that is created, a warrant ID number, right? And this is some of the metadata that we're able, and the timestamps and so forth are created. The judge can then approve or deny the warrant, and an officer can also retract. And what we're able to do is we're able to see if it happens after the time that the judge views it, if there's a retraction that effectively is like a rejection. So in our results, I'll show you pure denials and then denials plus retractions in some of our results. So then what happens is the notification is then sent back to the officer. He retrieves a warrant and can print it out. And then after he serves the warrant, by law, he has to submit a return. Okay, and that shows what he has found in the search. And so the data that we have is we have this timestamp data, and we have the submission time, the time the judge views it, the judge decision time, and also the time that it's served. And this is comes from the Department of Public Safety. And then we have approved warrant data that dates back to 2012. And we have, again, PDFs of almost every search warrant that's been issued in the state, except for those paper warrants and also sealed warrants. And not only the affidavit, but also the warrant and the return we have. And we also have a bunch of metadata that we're using. But the most important variable there is the officer, where we can look again at these questions of repeat play and judge shopping. And we've embarked on a massive hand coding and machine coding, a machine learning sort of work where we're doing word counts. We're looking at offense categories, whether it's a no-knock and so forth. Interestingly, I'm learning about linguists and computational linguists who have actually measures of obfuscation. So you might think when a warrant is closer to the margin, like let's say, if it's lower than a 50% probability of approval or whatever, that there might be ways, linguistic ways to sort of obfuscate. And so we're going to see if we can use these measures and see if there's obfuscatory language that's being used for certain types of warrants, and then looking at them by hand. And we're also, again, as I said, trying to get court data, to look at all kinds of things, warrant challenges, indictments, convictions, civil suits, and the like. I want to just point out 3 key limitations of our data. Okay, so we don't have the denied warrants. Like we see that there's a denial in the timestamp data, but we don't have PDFs of the denied warrants. We are trying desperately to, if anyone can help with that, we're talking to DAs and police to get even from one county if we can get those. But what that means is we then have to make assumptions about who the denying judge is. And so we're sort of looking probabilistically and making some assumptions in terms of the judge that's doing the denial. I could talk more about that in Q&A. The other big thing is I think is less of an issue if we don't have sealed warrants, we don't have the paper warrants. But I don't think that, that could be an issue, but I don't think that would have a huge effect on sort of the results that we're seeing. So to give you a flavor of kind of what an affidavit looks like, I just kind of picked out of a hat. I've also done a lot of redacting of information here, but this is basically kind of an affidavit for someone who basically is in a multi-unit apartment complex. And you can see that there's supposedly drugs and firearms at the location, right? So this is kind of what it looks like. And the key thing I want to kind of point out, a lot of this is largely boilerplate up until here. And what I've done is I've highlighted in orange kind of 2 key parts of the narrative. The first in orange is basically the officer's experience, right? And the second part is basically the facts of the case, okay, which is what I've highlighted in blue. And so what we've done that I think is kind of cool is we've basically, done some hand coding of these, and then we've trained sort of an ML algorithm to separate out the facts from the experience, and then we can do really conservative word counts, right? How many word counts? If they just read the facts, that would be like the absolute bare minimum. How much are they reading or not? Downstream. So that's something I'm not going to have those results today, but that's something that we are doing. And then so that's kind of what it looks like. I don't want to, in the interest of time, I don't want to. I can show you what a warrant looks like or what a return looks like, but for today, I'm just showing you what the affidavit kind of looks like. So we are going to have a polling question. The polling is going to be anonymous. And one of the really fun things about not having the paper, a full-blown paper, is that I can ask you what your priors are. And I'd be grateful if you could just respond to this question. And so, Kenitra, I think you're going to launch a polling question. Do I have to do anything special, make you a presenter or anything like that, or are we good to go?
No, I'm going to launch it. I should be able to launch it while you're still presenting. So just
okay.
a moment.
So I'll just read the question out loud here. I've told you that the median time for approval is under 3 minutes in the abstract. The question I want to ask all of you is whether you think that the median time, okay, for a judge overall is going to be longer for approvals, longer for denials, or about the same. Okay. So I just want to, I think the poll has just come up. And
And we won't have, I think, 100% approval because I think hosts can't vote. That's what I'm finding.
okay.
So you won't get 100% on
You
participation.
can cast your vote after. You can send me an email.
Okay, I'll tell you where I landed.
Okay.
Sorry, you guys ready? I want to share the results. You ready?
Ready? Drum roll. Let's do this.
Can you see it?
No.
Should I do stop? Oh wait, did I just share it? I hope I didn't. Can
No,
people see?
here.
Okay,
You
okay.
can
I'm
see
gonna.
it.
People can see the results, I think, in the poll quizzes box.
Yeah.
Most people should be able to see the
Okay,
results.
okay, cool.
Okay.
So
Okay,
for those who don't, I'll just read them real quickly. On A, the median time for approvals will take longer. That was 4%. B, the median time for denials will take longer, 77%. C, I think the median time for approvals and denials will be very similar, 19%.
Okay, great. So I just want to kind of so I will tell you, you guys are good, right? Polling the audience, I think, is always a good way to get the right answer. And so the answer is that denials will take longer, but it's not clear, right, that should be the case, because you have to think about what your baseline assumption is, your prior. Is it that I should approve, or is it that I should deny, right? Especially if you're a check on the government, right? And so you could basically think of a denial as someone reads, they see something wrong, and then they just immediately deny, so it takes less time. On the other hand, it might be that, you know, also you could say something has to be egregious for it to be a denial. And so for the guys who are approving 99%, the rubber stampers, right, we would think that they're just gonna, you know, quickly deny like the one warrant out of 1,000, right? But anyway, but the answer is what you guys mostly thought, which is that the denials do take longer, and I'll show you some results to that effect. So these, let me just put in kind of two quick caveats. These are extremely preliminary results. As I said, we really are taking to heart the works in progress aspect of this. I don't think these results are going to change that much, but we're still cleaning the data. The second thing I want to just say to everyone just is that we might be doing down the line some experiments and where we inform judges about where they are relative to the distribution, and we have a control group, and we look at what the effects are of information about their behavior with respect to warrants and see if there are peer effects. And so we would like to kind of keep these results kind of quiet, and so we don't want, you know, sort of lots of information getting out. So if you could please just, you know, ask us, at least if you're going to talk to judges and others in Utah about this work. But basically, the first thing is that the median decision time, here, this is a graph showing by district what the median decision time is for an approval, a denial, and a retraction, right? So you can see here, right, in red, right, there's only one district, District 6, where they take more than 3 minutes, right, for an approval, okay? And then the denial time is taking a lot longer, right? It's taking, you know, anywhere between 5 and 5.5, 5 and, you know, 10.5, I guess, minutes or so, right? So, but when you think about the relative time there, that's a huge difference, okay? So that's the kind of first thing to see. But there's also quite a bit of heterogeneity by district, right? You can see kind of, especially on the denial time, okay? Retractions, as I said, are, you know, a little bit, you know, they can happen instantly, but in this case, these are the retractions that happen after it's been viewed. And so they might be communicating with the officer to say, hey, I think you should retract this, make some changes, where it's effectively like a denial. So here, this is the same graph, except we, you know, put together the denials and retractions so that you can see in every district, right, denials and retractions are taking overwhelmingly longer than approvals. And again, y'all got it right in the poll, but like, it's not clear to me, like, you know, this is all conditional on what your prior should be about approving or denying a warrant. So sorry, this is a little messy, but I wanted to fit a lot onto one graph. So the second question is, how much do approval rates vary by judges? Okay, and we have a lot of judges in District 2. This is sort of includes Salt Lake. District 3 includes Provo, where Dane is. But what you can see, right, is there is, even though we have this 91% median overall, there's quite a bit of variation, right? And that we have judges that, you know, are near 100%, right, in their approval, right? And then, but we have judges, you know, that are as low as, like, you know, this person's clearly an outlier, but as low as 5%, right? And we have quite a bit that are in the 70% range. And so there's quite a bit of heterogeneity by judge, right? Which you might expect more heterogeneity because of judge shopping, maybe not. And so we're going to start to look at to what extent are the caseloads similar or not, and to what extent is judge shopping taking place. Okay. So then what we do in this plot is we take the districts and we say, okay, to what extent does judge tenure explain time, right? So these are dot plots. They're ordered by judge tenure. I don't know if you can see them, but basically you have the guy who served. This is 0.5 here in District 1. This is, you know, half a year, right? 5.2 years and so forth. And what you can see is that there's not much of a pattern, right, between the tenure of the judge and the time that they take on the warrants. Okay, so that's kind of the first thing to see, right? You see here they're taking relatively, you know, the same amount of time. Here, you know, there's no pattern, right? There's no correlation. And then when we start to look at, well, what about approval rates? The guy with the higher approval rate, right? So let's say you have 100% approval rate, right? You might think of that guy as like a rubber stamper, right? Who takes very little time, right? You might think of the guy who's inclined to be pro-defendant as like trying to look through every single application for any possible error, right? And he's going to take more time on the average, you know, on overall on an approval. But he might be faster on the rejections because he does them more. And what we're seeing here, right, is that it's hard kind of to discern patterns here, right? What we would see is a more linear kind of behavior. One thing to notice, by the way, is we're working on these graphs, but the x-axis varies a little bit by the jurisdiction. But even when you account for that, right, we're not seeing clear patterns. Now, what we're going to do is we're going to start to take out, you know, some types of warrants, like DUI warrants, down the line, and see if that then predicts approval a little better, because we think this is something that will definitely matter. So I've gone over my time, but I'm just going to say a couple of things about our preliminary conclusion. So judges are overwhelmingly, we think, no, I want to show, I'm sorry, I haven't shown my last graph. I want to show my favorite graph. I forgot to include that. Let me just quickly pull this up. And this is the, I almost forgot to show you the most important graph. And so just give me a second here. I'm going to go in and out of a screen share. And this is my favorite graph that I'm about to show you. So sorry about the, okay. Can y'all see this? You can see it. Okay, great. Okay, so this is the final graph, which I think is the most interesting graph. Okay, so on the x-axis we have the word count of every affidavit, and on the y-axis we have the time that the judges take on the warrant. Okay, now most of us in this Zoom room probably read around 300 to 400 words a minute. Okay, that would be like for a knowledge worker, like kind of intelligent grad school kind of knowledge worker. They're reading in the professors and kind of normal, most professors read kind of in this range. A professional speed reader, reads 1,000 words a minute. A double-spaced page is 250 words. Okay, and most people bill out time for expert witness testimony at about a page a minute. So that's about 250 words a minute. So what you can see here, right, is if I assume, that they're slower, 300 words a minute, all of these warrants below, all these affidavits are not being read in their entirety. All of the affidavits below the line, right? If I assume 400, which is this green line, 500, 600, right? These are the words that are not, these are the ones that are not being read in their entirety. Now you might say, well, hey man, this is a lot of, there's a lot of boilerplate. They're able to quickly, focus on the area that they need most importantly, which might be the facts of the case. And so we are going to be slicing and dicing the data that way. But there's so much overwhelming evidence here in terms of the numbers that it's probably not going to make that much of a difference. So this is one of the key graphs that we think is really important in terms of the check. So I'm going to end with just some conclusions, some preliminary conclusions, and then we'll move to Q&A. So the first thing I want to say is that it looks like overwhelmingly they're not reading the full affidavits, right? Again, subject to some assumptions about reading rate. Duration appears not to be explained solely by judge tenure and approval rates. We're going to have a lot more variables that we're going to be able to look at. Median approval rates are very high, right? But there is variation across judge. And that sort of suggests that we might be in an equilibrium that needs to shift. We'll also see with hit rates, what are we getting for this? Like how much invasiveness are we getting relative to the amount of crime that's being committed? And I wanted to say we've just scratched the surface of this data, and I want to just thank all of you. Look forward to your questions.
Well, thank you so much. I want to, let's see, I don't know how to, we can leave that up, or if you have a particular chart you'd like to leave us on, we can do that too. I want to invite everyone to turn their cameras back on. And I want to thank you for what was a fascinating conversation. I will say on my own part, and I'm sure on other people's, we're all kind of jonesing about the data itself and how exciting it is that you have all this data and how fascinating that is. I'm going to hand it off to Dr. Davies, Andy Davies, who's going to start us off with some questions. Andy.
Hi, thanks. Yeah, no, I was fascinated by this, and it's actually it's triggering a lot of questions that are sort of personally relevant for me, because we're also doing some work that involves timestamps, and we're also doing some work that involves kind of up and down decisions and things like that. I'm proud to be among the 70+% that thought the denials might take longer. I was curious. I don't know if this question might not make any sense, but obviously in a lot of other contexts, when we're looking at decisions like this, the first thing we would try and do is distinguish by type of offence or alleged offence. And I don't know if you're in a position to do that, or if there's any kind of breakdown that you can do, like maybe type of evidence sought or something like that. The reason that I say that is because we were just doing some work the other day on the time that it takes for prosecutors to make charging decisions, and the distinction in the amount of time it takes them to accept a case or decline to charge a case, which it turns out is not only different by the type of charge that is being kind of that is up for grabs, but also that the whether acceptance or denial takes longer depends on the crime that is being alleged as well. So I don't know, is there any kind of categorical distinction you can make among the warrants to say, I don't know, these are in this kind of case, or these are looking for this kind of evidence?
Yeah, so the answer is yes. What we have done is we have basically taken the statute for every single warrant. So it's interesting, right? There are some affidavits that don't even have a statute attached to them, right? They'll just, kind of list a crime broadly. So we are able on the warrant, almost all of them have the statute. And then what we've done is we have, very granular statute level data, and then we've aggregated it up to, property crime, violent crime, drunk driving. Drunk driving warrants are sort of in their own category, right? Because they're very fast. You have evidence that is disappearing in a person's body. So we would when we take those out, we're going to expect the approval rates to go down, and we'll see what the heterogeneity is like. But the other thing that we'll be able to do with judge shopping that I think is interesting is drunk driving is sort of a relatively non-discretionary crime with respect to judge shopping, you would think, right? You're going to just go to the on-call judge, try to get the warrant as quickly as possible. But what we're going to then compare that to other types of crimes to see the extent to which judge shopping is taking place as well. So short answer, yes, we're going to be able to segment it out by the offense type, by statute and offense type, and we're going to see how that has an effect on results.
Thank you. And I don't want to monopolize, but but just one other very small thing. I saw that you noted that in your data you only have one non-lawyer judge, and when I talk to my friends in Utah, they are frequently raging about the activities of the non-lawyer judges. I wondered why so, and so my immediate thought was, well, let's compare them, but it turns out you don't have any. Is that because? Well, why is that? I know they're probably in the smaller places. Maybe they're the ones using the paper warrants that you don't have so many of. Why is it that the non-lawyer judges are not showing up in your data?
Miguel, I think I can touch on this one.
Dane, you can take this. He has a better handle.
Yeah, so I think there's a pretty simple answer here, which is our data set is, it's fairly new, but it also has a lot of old data in it as well. And the non-lawyer judges that are reviewing warrants are a fairly new phenomenon in Utah. So 2016, there was a change in the laws about the requirements for the lower level judges in the trial courts, the justice court judges, that allowed for non-JD judges to come in. And so I think some of this is just that there were times in the data where that wasn't even possible, and it's just taken time for those judges to come up. I also think, and we haven't done a full survey yet, but I'm in Utah. I hear the same complaints about the non-lawyer judges. And I think in actuality, they're just taking a disproportionate number of the complaints. They're not as common as one might think, given the discussion surrounding them. We were surprised that there weren't more of them in our data set, but that's what we're looking at.
And we looked at the roster on the justice courts, and there were 6 total, right? And then there's 1 in our data. And is that right, Dane?
No, fairly confident there's just 1 in our data. I was just looking for examples and found 5 others. I assume that there's at least twice as many in Utah. So we're talking about at least 10 judges who are eligible to review warrants who don't have law degrees, just not showing up in our data for whatever reason.
So can I jump in here with a separate? I want to ask a separate question, but let me just posit that also might be that your police don't like taking them to those judges. Your cops may be some of those who are complaining about non-lawyer judges. I don't know. Has anyone challenged the legality of letting non-lawyer judges review search warrants? Because if there's a concern about that, maybe your cops are avoiding. Do you guys know?
That's interesting. We don't know offhand. That would be great to look at. Yeah, we can, once we get the administrative data from the courts, we could definitely look at that.
It wouldn't surprise me, given, again, we were surprised to see that few number of non-lawyer judges in the data. In terms of sort of this idea that the officers are aware of who the judges are and target their warrants, so that we're going to be able to test that. But what one piece of data we didn't talk about here is we've had research assistants simulate the judge warrant shifts based off of the sort of natural number of requests in a row that go to a given judge. And we're going to be able to sort of identify which requests were made on shift, which requests were made off shift, to see the extent to which, at least for the approved warrants, the extent to which officers are selecting specific judges. And whether that relates to the fact that they had a previous warrant in that case that was denied and they're resending it, or whether it's a matter of knowing, some judges have suggested this, some county attorneys have suggested this, that officers know which judges approve warrants and which judges cause problems. And they may delay the submission of the warrant to the next on-shift judge or just skip the process entirely.
So Dane, can I ask, it's fascinating, and I suppose you you'd sort that out too by those warrants that you have to go right away with, and those where you can cool your heels, right? The DUIs versus everything else, for example. But I want to double back to something that y'all talked about with respect to, looking at race and ethnicity. You referred to looking at African-American names and Hispanic names, I think at one point. Are you talking about looking at what the judicial perception would be of the race of the targeted defendants whose properties or persons you're searching? Or are you talking about the race or an ethnic identity of the officers, or both?
Oh, I hadn't thought of the officers actually, but I was thinking of the defendant, or the target, I should say, but the target of the search, because it's actually good in a way that we don't have their actual, it would be good to have their actual race, but when you're using names, that's what the judge is doing too, right? We're actually entering, and so our idea is to enter the head of the judge and see if there's any influence there based on the name. So there's great data sets with Hispanic names and so forth. But,
do you have the ability, and I guess maybe a question for Brett, but do you have the ability to look for other indicia that might signal race or ethnicity to a judge beyond names, things like zip codes or areas of town or particular linguistic tics that people use when talking about certain kinds of crimes?
Yeah, so what you can do is we can take the census tract data, and we're also going to look at income disparities as well. But you can basically have the census tract data, which is pretty granular, right? It's smaller than zip code level. I can't remember if it's tracts or blocks that are the smallest unit of analysis, but they're very, very small, and you can start to look there at the extent to which income and other, there might be other proxies for race, and you can just look at within a census block or tract, you can look at the percentage of minorities there as well. So I think we're planning to do some of that.
So I'm curious then, and a couple of people have I think been on and off asking about this. Well, let me back up. I got a lot of emails from people who wanted to be here and couldn't, saying, I don't think that that's what those data are suggesting. I'm objecting that somehow the data don't suggest, just the little abstract, that the warrant process isn't working. And I suppose that what they're assuming is that somehow the warrant process must be working. They didn't have access to your scatter plot there on reading times. But I suppose what they're arguing is somehow police officers are simply submitting good warrants, and that's why the warrant grant rate is so high, and that's why the rate they're being granted so quickly. How are you going to test that?
So that's one of the hardest things to test, right? I teach, investigatory criminal procedure. The probable cause doctrine is a mess. It's incredibly discretionary. So it's really hard I've thought a lot about this. There are some, no-knock warrants is an area where the standards are somewhat objective maybe, but for the threshold there. But what I can say, I think it's very hard to say, to get a quality assessment of the warrant. So here's some things I've thought of that I'm going to spitball with. So one is we could get retired judges in Utah or out-of-state judges to look at the warrants, or law professors, people who are competent to look at the warrants and see, okay, which, just to get a distribution of what is close and what absolutely should not have been approved, but it was. And then we could, or if we can I'm very open to thinking about this, because that's the fundamental. The other thing we can do is obviously look at the challenges that happen ex post, right? And so we can say, okay, there were X number of successful challenges by criminal defense lawyers. But the problem is there's obviously massive selection in that, right? Not every bad warrant is going to get challenged. So I am very open to suggestions on that front. Those are sort of the 2 or 3 things that I thought of that we could do. But again, because the doctrine is a mess, and then we can just read them, right, and point out, and so we've done that with got law students, and I've read a lot of them, and we've all read a lot of them, and so, and if there's objective things that undermine, the probable cause in them, and then that would be the other thing that we would look at. Okay. But that's a totally fair question.
Can I also
go ahead. I'm sorry.
Well, I think this really depends on what framework you're looking at warrant review with. That if it is if it's an economic efficiency process, then one would actually expect that we see warrant time reviews go down and down and down, almost to zero, as the officers get to know the judges, they get to know their preferences, they get to know what they're looking for, they get to be better and better at writing warrants, to the point where, you know, the overwhelming assumption is I'm just going to approve, in which case the time goes down and down. But if we're looking at this from a traditional understanding of judicial review, judicial review in this context it's asking the judge to make a determination as to whether law enforcement officers can infringe on another person's rights with justification. And if you're asking the judges to find sufficient justification to approve the warrant, then there's got to be some level at which we would all agree, or at least, you know, maybe everybody's levels are different, but there's some level at which there's so little reading going on, there's so little review going on, that there's no way that the judge could find that justification. At some level, we have to assume that they are going in, assuming the justification exists and looking for reasons not to approve, which again, I think is pragmatically, that makes a lot of sense, but that doesn't match with sort of the legal understanding of what judicial review is doing.
And I'm inclined to agree with you. I think a skeptic might argue that maybe the judges do that because the officers always submit such perfect warrants. I will not be surprised if you guys get that pushback. Stacy, you wanted to ask a question.
Yeah, thanks. So I've done some research with police. I did an ethnography, and one of the things I noticed is that they try to bypass the search warrant whenever possible, especially with cell phones. And so they try to get consent. And I was wondering if you have that data as well as to what type of search they're doing, if it's for cell phones, and does that take longer for the judges to consider, since it might be a little more complicated with the particularity of what can be searched on a cell phone?
Yeah, so unfortunately, right, if they give consent, right, if it's a consent-based search, they don't need a warrant, right? So that's not going to show up in our data. And I want to be very clear, like overwhelmingly, like that's where the action is, right? In terms of right, motor vehicle searches, all kinds of searches, right? Like they're almost always consent-based, and so this is just the tip of the iceberg, but that I think is really important. It's a lot harder to study, right? Because it tends to be a much more informal process. And so systematically collecting that data, I think, would be really challenging. But I think that absolutely, and so ethnographic methods might be the way to go, or other qualitative methods. But if you want to get the whole universe or sample, like it's very hard, I think.
Well, I was actually just wondering what was that?
Well, this is an answer to your question. I just want to shout out Rosanna Summers at Michigan has like a series of just incredible papers and experiments that show exactly what you're suggesting, which is people just consent to all sorts of things. Like she has this incredible experiment where she has a person in a lab coat go in a room and say, hey, before we start our study, can you unlock your phone? I'm going to take it outside and look at it a little bit. And 95% of the people gave up their phones, whereas if you ask them beforehand whether they would, 95% say they wouldn't. So that's a real problem with warrants. And I think I'm not sure if it's a problem for our data set, but it's certainly a limitation in the sense that we're not capturing all searches. We're capturing all legal, searches conducted after obtaining a warrant, but there's a lot going on that warrant data isn't going to cover.
Let me just say here as well, wouldn't it be, isn't part of this related to hit rate? Because one of the things I was thinking of, that part of what moved the stop frisk litigation in New York, I think, was some very compelling evidence about the low hit rate on all of those interventions, right? That was part of what was kind of so outrageous. It would be really interesting on the ones where you evade a warrant, right, by getting consent, what hit rates look like. I don't know any way you'd get at it, but hit rates versus hit rates on yours. And I assume you're also going to do hit rate studies once you have a chance to work your way through the rest of the data, which you could apparently spend the rest of your lives doing.
Yeah, that's right. So that's absolutely right. So what we have that's gold, I think, is we have all the returns, right? And so the problem is like logistically, like it's really to code returns, like when there's thousands of things that they can find, and figuring out how that aligns with what was in, the affidavit or warrant it's really challenging, right? And so we're working, right? That's why we have Brett on this team, and we're collaborating with others, but we're trying to schematize that, and then we have to make sure it's validates or whatever algorithm that we're going to use to do that with. But yes, I think hit rates are super important. And then what then becomes the question is like, it helps you get at the social welfare consequence of this regime, right? I think this is an area of potential over policing that's just completely not studied, right? And so I think the hit rates are absolutely critical, and but it's labor intensive to do it. And so we're going to work with people who are good with text analysis to do it, but it is going to take a while, and we have to think carefully in a principled way about how to do it systematically, and that's definitely one of the challenges. But I think that's absolutely right.
I think it'd be, and again, I'm sorry for taking the moderator's privilege and hogging, but people are being shy and not putting their hands up. So here you go. I assume there's a question that there are two different questions about learning, right? Because I suppose one question would be, or I guess multiple questions about learning. Do you know who reviews the returns?
Yes, we have.
Is it the judge who grants, or is it somebody?
Not always. No, it can be. So there's basically what they have shifts for the judge. It's almost always the on-call judge, but because the return can be filed within, I think, 30 days, it's oftentimes not the original judge. But they can also send it back to the original judge as well.
And do warrants expire automatically, or are they given expiration dates?
Yeah, they impose, like, depends on the type of warrant, but yeah, most of the time they have some form of expiration date on them.
I'm asking because I'm really curious about what the signals would be, to the extent that you have judges that are receiving signals and learning, even if not consciously, about what's happening. One signal might be a warrant on which expires without a return, although I have no idea if a judge would ever know that, versus the extent to which judges are seeing their own warrants produce returns.
Yeah, that's great. Okay, so basically the idea would be, let me just see if I'm understanding. The idea would be like, if you're doing a lot of searches without a return, right? You're not finding anything, that's going to undermine the trust. So the probability, like in the next round, your probability of approval should go down over time.
If you know that, two things would have to happen. You would have to know that you were getting a no return, right? Mm-hmm. First thing, and two, it would have to matter to you. That your prior seems to be the judge's care. I'm agnostic. In the sense that, like, you'd have to assume that it matters to judges whether there are returns on the warrants. I think that maybe I'm wrong, but I think for some of us might argue that the probable cause standard is so low that there might be a feeling among some judges that, I think the last research was somewhere between 47 and 49% likelihood of, was I think the standard.
Yeah, the 1982 it was lower. It's like 42, 43%.
Yeah, and more recently it's gone up a little bit. Yeah.
Oh, okay, that's what okay.
I think I had that study, but if you don't think that returns are important indicia of whether the search should have been authorized in the first place, then they won't matter. If you think, on the other hand, that returns are important indicia that you're making the right decision, then it will matter. And so I don't know how you would measure that, but I'm
well, we could just interview judges, right? We could just go talk to some judges and ask, to what extent do they factor in returns, or to what extent do they look up the returns, and I think that's something we could definitely do. But we could also just look in the data and see if that matters or not, right? If the officer hit rate, does that, at least that's very easy, right? If there's no return filed, or if there's a zero, we could definitely do that dichotomous, coding.
You could also, Yeah, presumably you could also do residual effects of reversals.
Yeah.
Across all pools of judges, how much that matters. We are at 4:07, and so I just want to flag it because we only have 15 minutes, and I want to be cautious about people's times. While I'm saying this, I'm going to ask Kenitra if she wouldn't drop a couple of links into the chat from me. I just want folks to know about our rural criminal law externship. We are placing law students in rural prosecutors and defender offices. Students from any law school can apply and participate in our program. It's a credit-bearing program, up to 3 externship credits. Also want to let folks know we are hiring. So if you want to do cool research, information is in the chat. But I want to wind down by asking our guests to tell us, what more can we help you with? What are you looking for? How can the folks who are here and interested in what your work is help you advance the ball?
Well, thanks for asking that. I'm going to answer it specific to this project, and if I may, I'll also answer it more generally related to our general research objectives. Would that be okay?
Sure.
Okay. So I would say specific, and Dane, feel free to chime in
Sure.
on any of this. So I would say specific to the project, I think the question that Pam asked is really important. Like, what can we do? Are there ways to measure, like, quote unquote, objectively or as close as you can, whether the quality of the warrants? That's one question I would want to know in terms of probable cause. Okay. A second question would be, like, I've given you some ideas of what we can do with the data. What are, there's some things in the chat that have come by, but are you, what would be some of the killer questions that you would want to know, that you would have? And then thirdly, I'll just speak more generally on kind of what we're about. We've done a lot of really interesting, we are really into, like, doing program evaluation and seeing what works. By the way, there's a group, so we've also worked a little bit with APM, American Public Media. They have a research division, and they're looking in Minnesota, I think in St. Paul, they banned no-knock warrants, and in Minneapolis, they didn't. And so they're going to look at, what the effects are of that downstream. So we're really interested in working with groups that want to know the answers in a rigorous way to questions. Another thing that we have done is a restorative justice intervention, where prosecutors are randomizing offers of restorative justice versus the status quo. And because they only have, a finite amount that they can, the cases that they can take. We have funding for that project. That's something we'd be really interested in partnering with any of you who are prosecutors or from NGOs that are doing restorative justice work. But more generally, we're just interested in getting a feel for working with prosecutors, helping them make data-informed decisions, also with defense lawyers and judges. So that's my pitch. But Dane, why don't you pick up the ball with anything I've left out?
I didn't hear the first point you made. Did you talk about the denied warrants?
Oh, no, I did not. That's one other thing that would be really helpful.
One, and I think this is a pretty significant limitation, and Miguel pointed it out early in the slideshow. But we have data sources from a few different places, and going forward, I think some of the really rich material is going to be in evaluating the language in the affidavits and the warrants and the returns. Obviously, we don't have warrants or returns for affidavits that weren't approved because those things don't even exist, but we're also missing the affidavits for the warrants that weren't approved. We suspect this may be like a true data missingness problem because there's not a lot of legal or even procedural reason why you would keep affidavits that weren't approved. And so in discussions with sheriff's offices and some Utah organizations that have data, we haven't been able to find any. But if anybody has good connections with sheriff's offices or county attorneys and think that they may have some of these files, we're not going to have all of them. But if we could get some of them and evaluate what those denied affidavits look like, that would be really valuable to us.
And would you all like to drop some contact information into the chat so anyone who thinks they might have that information could reach out to you? It's on, I think your bio information is on our flyer, but
Absolutely.
we'd love to
Here, I'm
make
doing
that
it right
available.
now.
I can put mine in, yeah.
Terrific. And let me let folks know as we round out our time together that we are working on our spring and summer schedules for 2023. If you do have a work in progress that you'd like to workshop with us, please do let us know. This is such an exciting opportunity for us to meet with people who are doing great work, hear about it even in the very early stages. And as you saw today, we are early stage friendly. This is not a place where you have to have a draft and a complicated set of footnotes or metrics to bring in. This is a pretty supportive environment that gives you a chance to showcase what you're doing, and sometimes just that little push to actually put something together, which some of us need sometimes, not just saying. And so we thank you so much for joining us.